know when? Good afternoon. The Public Safety Committee will now come to order. Madam Clerk, will you please call the roll?
Alderman Oldenburg. Alderwoman Clark Hubbard.
Here.
Alderwoman Keys.
Here.
Alderwoman Velasquez.
Present.
Alderwoman Sanye. Alderman Aldred.
Present.
Chair Narayan.
Here.
Alderman Oldenburg. We have 6 present. We have a quorum.
Thank you, Madam Clerk. Quorum being present, I will now entertain a motion to approve the minutes of Thursday, June 13th, 2020.
So move.
It's been moved by Alderman Aldridge, seconded by Alderwoman Saunier, that we approve the minutes. Madam Clerk, will you please call the roll?
Alderman Oldenburg. Alderwoman Clark Hubbard.
Aye.
Alderwoman Keys.
Aye.
Alderwoman Velasquez.
Aye.
Alderwoman Sanye. Alderman Aldred.
Aye.
Chair Narayan.
Aye.
Alderman Oldenburg. We have 6 aye votes.
All right, with that, we have sustained the motion to approve the minutes of Thursday, June 13th. We have 2 board bills for discussion today, Board Bill number 11 and Board Bill number 12. We'll just take them in that order. Alderwoman Saunier, you are recognized on Board Bill number 11. And if you do have individuals with you who are a part of your presentation, if you could just let us know that, that way they won't be subject to the time limits of public testimony if they're actually here with you.
Thank you, Chairman Narayan. I do have some folks who are here for as a part of the presentation as well as expert witnesses. So if you want me to kind of go through the presentation first. And
Certainly, yeah, however you'd like to take it. I just wanted to let you know that just up front.
Thank you. All right, good afternoon, Chair Narayan, members of the committee. Today, I'm here to talk about Board Bill 11, which is all about the regulations for attorney access to city-owned facilities. I think that when there's not clear policies and clear processes for things, that leaves the room for confusion, and we've seen a lot of instances, and we'll hear from some folks today who are directly impacted by those, by some of that lack of clarity on some of the practices. And so Board Bill 11 is going to set some basic regulations for attorney access to city-owned detention facilities, and we can go to the next slide. So just for a little summary of the bill, a few things, we can go to the next slide. A few things that it does. Firstly, it just explicitly allows attorneys to bring their cell phones, their computers, documents, books, and any other items that they need in order to adequately represent their clients. It establishes a clear time frame for when attorneys can have non-contact and contact visits with detainees, and it creates a grievance process for attorneys who believe that they have been unlawfully denied access to a detainee. The next slide. So just a couple of things to get us on the same point. I wanted to pull out some definitions. So just want to be clear that we define access as the physical appearance within a detention facility. An attorney, anyone who's practicing law, who's a licensed practitioner of law, and we know that sometimes that's the actual attorney, sometimes it is a substitute attorney, so we just want to be clear. We know that a detainee, we're defining a detainee as someone who is a person that is deprived of liberty and they are being kept under involuntary restraint, confinement, or custody in a detention facility in our city. We define detention facility. I won't go into that. I think we're all clear on that. On the next slide. The 2 definitions that I do think are really important to be clear on is the difference between a contact visit and a non-contact visit, which is actually very simple. It's just whether or not there's a physical barrier between the attorney and the client when they see them, but just so that we're clear on what we're referencing in those sections. And then the next offense is retaliation, which again, I think is something that's very important to be clear on before we hear from folks we hear from today, that we define retaliation as any adverse action taken by a detention facility staff member against a detainee, an attorney, or other detention facility staff member based on that person's role in a visit or telephone call, investigation, inquiry, or anything else. Okay, so the first part of this bill to really dig into is just really important to be clear that these provisions in this bill and this ordinance will only apply to attorneys who are seeking access in a city of St. Louis detention facility and visitation with detainees in a said facility. You can find the specifics of that on page 3, lines 4 through 5, but we just want to be clear what we're talking about. And then we are going to jump back to what a non-contact visit is. Again, that is when there's a physical barrier between the attorney and their client. And so this bill proposes that between the hours of 7 a.m. and 9 p.m., there are no restrictions on these non-contact visits. And this would apply to any detainees that were being held in segregation or solitary confinement as well. And then it would require that between the hours of 9 p.m. and 7 a.m. that you have to provide 1 hour notice for those non-contact visits. Again, the hours of 7 a.m. and 9 p.m. are just the usual visitation times, so we're just kind of working within the framework of what exists and defining it. And then for contact visits between the hours of 7 a.m. and 9 p.m., you would need a 1 hour's notice. So the really big difference there is if you're doing a non-contact visit between 7 a.m. and 9 p.m., it's not necessary to provide 1 hour's notice, but if you are doing a contact visit, then it is necessary to provide 1 hour's notice between that 7 a.m. and 9 p.m. time frame. And then this next slide, I just want to make sure that the committee members are aware that this issue has been something that's been well talked about, particularly in our judicial sector. And so this is actually a screenshot from Judge Elizabeth Hogan's order that was issued on April 23rd, 2024. And in this order, you can see that she's addressed it to Commissioner Clemens Abdullah as well as Sheriff Vernon Betts for the city of St. Louis. And you can see official clerk it was in and the date. But that's really important because essentially what this order says on the next slide is it really is basically saying detainees shall have access to items needed for note-taking when they are visiting with their counsel. And on the flip side, the order also said that attorneys shall be permitted to bring to a client visit any items that are necessary for them to adequately represent that client, including but not limited to computers, cell phones, documents, books, and other writing utensils. And the order also specifically says that the paper pass shall not be locked during non-contact visits with attorneys and defendants permitted to sign necessary paperwork. And so that is really important, particularly these last two sections are important because this order, I think it just shows the validity of the bill in front of us today because essentially the ordinance is saying what a judge has kind of already declared and kind of already put into place. We'll hear some folks today that will speak to how that has played out. But again, in order for attorneys to be able to adequately represent their clients and in order for detainees to have their constitutional rights of representation, they have to be able to ask questions. An attorney may need to, do a little research and pull up a question. They may need to show their client some documentation while they're having that visit. And those are things that they often rely on technology. And so any blocks to them not having technology really can impact their efficiency to adequately represent their client. And again, this paper pass part is also really important because even if it is a non-contact visit, attorneys need the right to show their clients documentation and to share information. There's going to be some folks who talk about that, but that's important at all stages, especially during a trial stage where changes are happening very quickly and attorneys have to be able to share that information very quickly. And so you'll just notice that on section E, pursuant to these judge orders, in pages 3, line 21 to 22, it specifically addresses essentially what the judge said, where we're saying that attorneys shall not be prohibited by detention facility staff from bringing their cellular, cell phone, their laptop, their computer, their cameras, or any other equipment they need. And then on part F, an attorney shall be permitted to pass papers and documents to a detainee even during non-contact visit. And the big thing that this bill also does is it establishes a grievance process. So I think we've reached a point where there are regular complaints and regular issues of attorneys feeling as though they've been unlawfully denied access to their client. And so this bill proposes that we set up a grievance process where any time that an attorney is denied access, the facility, the commissioner, or the sheriff, whichever one is in charge, they have to provide written notice within an hour that they've denied access, and they have to say why they've denied access. In that notice, it needs to be affirmative that they did deny access, and then they need to provide a date and time that they did denial and the specific reason for denial. And I think what's really great for all of us is that all of that would also become a part of open and public records under the Missouri Sunshine Law, so that we have an actual grievance process to see how often this is happening, to see the reasons that it's happening, and for the public and for all of us to be aware of those processes as they happen. And then once this process is, established, an attorney has the ability to file a complaint with either the Civilian Oversight Board or the Detention Facilities Oversight Board if they believe they've been unlawfully denied. And an attorney is not required to complete the administrative process in order to file a legal action in the 22nd Judicial Circuit Court. So just want to make sure that we're making it clear that this isn't in any way meant to impede any other processes that they might want to take. This is just us setting up a process within our processes directly outside the judicial branch for those complaints. And if a judge adduces after a presentation of evidence that, detention facility staff member, commissioner, sheriff has violated any of these sections, the judge is authorized to assess a civil fine between $100 to $500 against that person. But as I said, that is the context of the bill, so I just wanted to make sure we were all on the same page with what we were discussing, with what the ordinance attempts to establish, that we knew what all of the definitions were, that we knew the specific problems that we were aiming to address, and that it was abundantly clear that it is a reason that we are having this conversation, that it's been well documented, and it's gotten to the point where even a judge has given an order. But the next part, I think, is to know, given all that action is taken back, how has it played out? And obviously, we can talk amongst ourselves, but it's always most important, the people closest to the problem are those closest to the solution. And so we want to bring the public defenders and others who have actually had to use this process to access their clients to be able to speak to their experiences thus far. Okay.
Thank you, Alderwoman.
And if you could just state your name for the record, please.
Matthew Mahaffey.
And do you swear or affirm that the testimony that you're about to give is true to the best of your ability?
Yes, I do.
All right, please proceed.
Thank you, Chairman. I appreciate you all having us here, and I very much appreciate the board bill proposal, because I think it codifies and accomplishes, or would accomplish, what is needed in order to make the jail a place that we can at least have constitutional and legal access to. It's not lost on me today, the timing of this. I know it was unintentional, but we are supposedly celebrating on June 19th the eradication of slavery. The 13th Amendment talks about how it's indentured servitude is no longer allowed except as punishment for a crime. And there's a great documentary on that called 13th, but what is happening at the Justice Center, I would say, is we are punishing people who have not been convicted of a crime. And one of the ways we're doing that is by denying full access or meaningful access to the people that represent them. And to that point, just from a numbers standpoint, looking today on the city's website, there are 680 individuals confined at the Justice Center, 563 of which are people of color. We continue to do what we say we eradicated, and we continue to do it over and over in the exact same way. And I think this bill does not obviously make that go away, but it allows for access to hopefully stop that. Last week, I talked a little bit about specific examples, and I don't want to rehash those with the committee since you were here, but just since then, a number of other examples have come to my and Ms. Worth's attention with regards to access. On the 10th, we had someone go, which would have been Monday of last week, for a professional visit, not to see in a professional booth, not a contact visit. They waited at the front desk for 45 minutes while the front desk person, who was very helpful, attempted to call the unit. It would have been 3D. After 45 minutes saying, we're not getting a response from anyone on that unit, you might want to come back another time, they left. On the 11th, we had an individual go visit at 9 a.m. because on the 10th, they had been told, this is a different incident, that the paper pass wasn't open at that time. They should come back the next day at 9. And as Alderwoman Saunier pointed out in the order from Judge Hogan, that is supposed to be open in the professional booths. When this individual arrived at 9 o'clock, they were told that that booth was not available to be open that time because there was no one on that floor to open, but they could see the person without a paper pass. But the paper they had needed a signature, and so they couldn't do that. Tuesday, we had an attorney go for a visit and was told at the front desk that he was not allowed under any circumstances to bring in any electronics at all during his visit. He asked for a supervisor. He had a period of time where he had to wait. He eventually got approved to go up, but there was a delay of about 30 minutes from that. And then one thing I did also want to mention that I didn't mention last time about the copy reality. In late May, we had an attorney go over with 400 pages of medical records. They had to make copies of those medical records before they could take them to the client, but then the paper was taken by the jail, given to the client, and the attorney was not allowed to take a copy with them to go over with the client in the professional booth, rendering that access very inefficient in order to review with the client. Why is this important? Obviously, it's outlined in the board bill, the constitutional, rule-based case law reasons why this access is important, but more than that, that is a pre-trial detention facility. Every single person that is detained at the City Justice Center is accused of something, but they have not been convicted. They are innocent until proven guilty. Failing to grant access in a meaningful way delays that reality for every one of those individuals. They will be there longer. They will not have access to counsel. They will not be able to review the information that they should be able to review to make an informed decision. And what that leads to is individuals making decisions based on how they can get out of there fastest. That is injustice at its peak, because someone is deciding in that instance what they want to do with regards to a criminal conviction based on not wanting to be in a facility where they don't have access to the information needed to make that decision. I think this bill addresses all of that. And I hope that as you look at it, if you have questions for me or anyone else that's here, I know we would be more than willing to answer what we can, but that's what I wanted to emphasize to the committee today. And I'm going to invite up now, well, I'll ask for questions from me, then I'd like to ask Erica Wurst, who's my co-manager, to come up and talk a little bit about our efforts to attempt to meet the jail in ways that we could have meaningful contact outside of just direct in-person communication, and why we hope that that can be accomplishable as well.
Absolutely. And do any members of the committee have questions before we move to Ms. Wurst? All right, not seeing any hands online. So yes, let's move over to Ms. Wurst then. And we'll circle back around. I think we'll probably have questions for the entire presentation at the end. And could you please state your name for the record?
Sure, it's Erica Wurst. I'm the Deputy District Defender of the St. Louis City Public Defender's Office.
And do you swear or affirm that the testimony that you're about to give is true to the best of your ability?
Yes.
All right, please proceed.
Thank you very much. Thank you for having me. My efforts mainly with the jail have been to try to get us virtual access with clients. I've been trying to get this done for several months now because I've talked to other public defenders in other jurisdictions who are able to do Zoom visits or WebEx visits with their clients, and it is extremely helpful for them. It has gone nowhere. I have sent many, many emails. I have asked for sit-down meetings with the commissioner, with other members of the administration over there. Nothing has happened, particularly after the jail stopped opening the paper pass for us. What we were told was you can leave paperwork for your clients in a tray at the front desk, and then we will take it up and give it to them. And of course, for discovery, for things that are incredibly sensitive, we just can't let that happen. We cannot let the COs or other people at the jail who are not our clients have access to our discovery. It would be unethical of us. And for some things, such as like a HIPAA release or other, just something we need a signature on, a lot of that stuff has a lot of legal jargon. A lot of our clients are not able to read that and understand it readily. As Mr. Mahaffey said, sometimes we're talking about medical records or stuff like that. We need to be able to talk to our clients about what we are asking them to sign or about what we're reviewing with them. So I tried to set up with the jail virtual visits and said maybe if we can drop off paperwork in a manila envelope or something like that, and then set up a virtual visit, just a quick Zoom call, so that we could go over it with the client. Maybe that would alleviate their problems with the paper pass, whatever they are, and then we would be able to discuss the stuff with our clients. I was told there's no Wi-Fi at the jail. I don't know if they have gotten Wi-Fi since or if they had that at the time, but there definitely is Wi-Fi at the jail. I was in a contact visit with a client of mine just on Tuesday, and I had my computer with me. I can see the networks that are there. There's a very strong signal on a locked network in the jail. I was told there are certain regulations. What I was told was CJIS is a data security regulation that the jail must be in compliance with. I responded and asked for them to point me to the regulation and got no response to that. I tried to do my own research. I found...
Can I stop you just for 1 second?
Sure.
So the CJIS regulation, that's in regard to
to
the Wi-Fi?
It's about data and data storage at carceral facilities
Okay.
in Missouri.
Okay, thank you.
Yeah. So I just did my own research and found, I believe, the regulation that they are referring to. I read through the regulation. I responded back an email and said, is this the regulation you're referring to? And I went through it and said, I don't believe that this would actually apply to a simple Zoom call with a client. I think that would only apply if you were storing secured information on the jail servers. And I got no response to that email. I have just tried many, many times with many people to try to get virtual visits done, both because it would allow us to go over the paperwork with our clients, and one of the reasons we were being told by the jail that they are cracking down so much, if you want to call it that, on us giving paperwork to our clients is that they say there's a possibility that we are somehow smuggling contraband to our clients via paper, that we have perhaps dipped our paperwork in PCP or some other narcotic or drug, and that we are smuggling drugs to our clients via paperwork. So it seemed like virtual visits would also alleviate that problem from the jail because there would be no paperwork going back and forth. But I've gotten nowhere. They have stopped responding to it entirely. That is all I have.
Does anyone have any questions for Ms. Wurst at this time?
Thank you.
All right, thank you. Hello, ma'am. Could you state your name for the record?
Sure, my name is Susan McGraw.
All right, and do you swear or affirm that the testimony that you're about to give is true to the best of your ability?
I do.
All right, please proceed.
Thank you. Good afternoon. My name's Susan McGraw. I'm a criminal defense attorney, and I'm the director of the Criminal Defense Clinic at St. Louis University. I'm here to tell you that I've done nothing but criminal defense with a short municipal judge exception for 35 years. I've been in every prison in the state, as well as other states. I've been in probably 24 jails. What I need you to know is the way that these rules by Jennifer Clemens Amdullah are not normal. They're not, no jail has these policies. No jail forbids a phone. In fact, when I go to visit people in rural jurisdictions, I'm allowed to take my person with me, as well as my phone, my notes, my paperwork. So this is really, really not normal, what's going on at the Justice Center. The other thing I wanted to point out to you is that attorneys have ethical obligations, right? Everybody knows that. We have a very specific set of rules that we're required to adhere to, or we will lose our licenses. One of the things that's happening right now is that our clients are being denied effective assistance of counsel. That effective assistance of counsel is guaranteed not only by the United States Constitution, but also the Constitution of the state of Missouri. If we are not allowed to share documents, watch videos, get signatures from our clients, chances are that a judge down the line is going to find that we are ineffective, that we have failed to provide our clients with legal services that are sufficient to pass constitutional muster. So what's going to happen is that I can't show my client their police reports. My client goes to trial and my client is convicted. And the judge reviews that conviction for effective assistance of counsel, and they're going to say, no, you did not provide effective assistance of counsel. Two things are going to happen. Number one, it is going to have a very bad effect on my professional licensure. The second thing that's going to happen is that judge is going to say, I'm dismissing this conviction. I'm throwing it out. This person did not get effective assistance of counsel, and we are going to start the whole process over again. As you probably know, the 22nd Judicial Circuit has a lot of cases waiting to be tried. To continue to refuse us to provide appropriate representation to our clients is going to make that problem a lot worse, because those folks are going to get a second shot. No one has the ability to continue to do this over and over again. This bill will cure a lot of those ills. In fact, if this time the jail chooses to follow the orders of the court, which it has clearly not in the past, it would be a great boon, not only for the judicial circuit, for the city, for our clients, but it will also allow people who are representing criminal clients to rest easy at night, knowing they're not going to lose their license because of something that the CJC did. Thank you for your time. I appreciate it.
I just have one question for
Yes,
you.
sir.
So first off, thank you for coming today. I knew that I recognized you from my time at SLU. I couldn't place you right away, but I did not take your clinic. But I know
Your loss.
I genuinely was. I was in Ireland at the time where I was hoping to take your clinic, my 3L year. So 6 of one, half dozen.
Yes,
of
Ireland's pretty good.
But so you did mention the ineffective of counsel here, which is I think everyone who has a law license knows that's the last thing that you want to be accused of. Now, are you currently, are members of the defense bar currently bringing these complaints to judges that these
Yes.
cases are in front of, saying that this facility is limiting my ability to adequately represent my client?
Absolutely, 100%. I have done it myself. I was barred from the jail for taking a photograph of a man in a wheelchair who'd been dumped out on his stomach in the jail. That next day, Vernon Betts, and I don't know who at CJC, banned me personally from being in the jail. I had to go to Judge Hogan. She wrote an order instructing them to let me back in. I am not the only person who's been through this. Just this week, I know that the judges were alerted again as to issues that the public defenders and other defense attorneys have had. And it's unsustainable. I mean, that's what I would like you to know. This is unsustainable. It is the Wild West in that jail. And someone needs to do something. We do bond hearings all the time, my students and I. I'm an active criminal defense attorney still. I had clients, small elderly clients, who were getting beat up and their food taken from them every day. And there was absolutely no incentive. There was no movement. They are torturing people in there. And if they're not going to listen to the judge, then it is incumbent upon the city's government to try to make the necessary changes.
Understood. And in your professional opinion, with the experience you have, if we continue down this route, do you think there's a real possibility that judges are going to begin dismissing these cases with prejudice against people?
The judges have already been dismissing cases with prejudice for people being overly confined.
And could you
cannot-
explain that a little bit to my colleagues who don't have the legal background?
Yeah, the judges cannot say, this person's been treated terribly. I'm going to dismiss their case. What they can say is this person's been there for too long. And because they've been called to trial, the state's not ready, they do dismiss the cases. what you're also going to see is people unwilling to take cases in the city. The city is dependent upon the private bar as well as public defenders to take these cases. No private attorney in their right mind is going to take a case where they know they could get their license suspended because they can't access their clients.
And, go ahead.
I just want to say my husband is a circuit judge, just for disclosure.
Sure. And do you have any of these issues when you're in other jurisdictions, when you're in St. Louis County, St. Charles County, Franklin County, on and on down the line?
No, I do not. And I am also a federal criminal lawyer. I travel all over. I've traveled out of state. Nothing even approaching this anywhere. Like I said, I don't need to make an appointment. They let me in, 95% let me bring my briefcase in with me. This is such an anomaly. And I'll add,
Absolutely.
because I never stop talking, that the prisons where people are convicted and incarcerated do not do any of this. I've been to every single prison in the state, and none of them do anything like this.
Thank you. Do any of my colleagues have any questions for Professor McGraw?
Thank you.
Thank you. Sure, yeah. Yep, absolutely.
Comes up and
Starts
does best.
throwing things.
But you asked Professor McGraw a great question, and I think the importance of her testimony can't be overstated. I wanted to kind of flush out just very quick to your question about ineffective assistive counsel and how access, what that looks like. These are examples from this week alone from our office. We have been told, don't come visit in the morning because the people are being transported to court. Don't come visit at 11:30 because that's trays for lunch. Count is at 2 from 2 to 3, but if you show up at 1:30, they'll say, well, it's almost count, so why don't you come back at 3? We had an attorney frequently told, don't come at 3 because it's shift change. And then just yesterday, an attorney go at 4:30 to see someone, and they were told, this is really bad time because it's trays for dinner. So between 9 and 4:30, at least every other hour, if not every hour, we have been given a reason in the last 2 weeks why we shouldn't come at that time, but should come at another time. That is the opposite of what access is and leads to, I think, it's very likely to lead to what Professor McGraw. I just wanted to.
Have they indicated a good time to come? Have they said, don't come at, 3, come at 3:45, because that's the sweet spot for us?
That has not been indicated, other than the example I gave earlier where someone was told on Monday to come back at 9 the next morning because there'd be a likelihood that the paper pass would be open, but when they got there, they said that it wasn't. So it's always been what times are bad, not what times are good.
Okay.
And I want to, I'll let Javad do what he does best now.
Sure, absolutely. All right. Could you state your name for the record?
Javad Kazali.
And do you swear or affirm that the testimony that you're about to give is true to the best of your ability?
I do.
All right, please proceed.
So a little bit about me. I am a former federal prosecutor. I worked for the Department of Homeland Security for 10 years, prosecuting cases in administrative courts with the Joint Terrorism Task Force. I'm also a civil rights attorney, and I do criminal work in St. Louis. Just to answer a few of the questions that you've had, St. Louis County, you walk in the door, there's a desk with 2 people. In the big room, you say who you are. They go into a computer. They ask, do you need a room for your person, or do you need an attorney room with a slot? You tell them. 10 minutes later, you're in the room. Every single time. There aren't all of these restrictions. There aren't all of these excuses. That's how it works. Anything beyond that is considered an anomaly. And if something happens beyond that, they come down and talk to you and explain to you, hey, something's happening right now. We need you to be a little bit patient, but we're going to get you in there. Even during the height of the Ferguson uprising, where I had clients being arrested and shifted around all the time, St. Louis County never had problems. Even Ferguson, while there are protests outside of their doors, I was able to get into my clients within minutes. One thing that I think isn't mentioned here is everything has been from the point of the defense attorney. But as a prosecutor, you're ready to go to court, everything's ready, and then the defense attorney comes in and says, Your Honor, I'm not prepared to go forward because the jail hasn't given me access to my client. So now everything gets pushed again. That is justice delayed for victims also. Talking about our ethical obligations, I think the previous speakers did a great job about talking about ineffective counsel. One other thing that we are obligated to do is to give immediate updates to our clients. In the criminal setting, often these cases just kind of sit, nothing happens. And then when things start to happen, they happen quickly. And you have to go to your client and tell them what happens, because ultimately, we're professionals here, but our clients get to make the final decisions. We say, should I call this witness? Should I not call this witness? Do you want to take a plea bargain because they've got this new piece of evidence? And if you can't inform your client in a timely manner, explain it to them, not just past papers, then you're doing them a disservice and you're delaying these cases. Every delay costs taxpayers money. When a public defender sits in a lobby for 30 minutes, they're not sitting for free. They don't have Wi-Fi, so they're not working on their cases. They're just spending taxpayer money because somebody who's not trained, has no background of this, has made this arbitrary decision to not let them in. Over the last 15 years, we have seen a global change on how criminal justice because of the iPhone. When I do a civil rights case, a police shooting case, they virtually always are dependent on videos, on pictures. These are the types of things that we have to show our criminal clients in person. I don't know of any way possible. I mean, I'm pretty good at pantomiming, but I don't really think I can do a dashboard video without my laptop in front of me to show them the video. These devices are essential to your defense. But let's be clear why we're here. The St. Louis Justice Center is a cauldron of abuse and civil rights violations. This is the way that the Public Safety Department, not the Public Safety Department, the jail oversight and the Sheriff's Department intend for it to be. Virtually everything that you've heard has been attempts by Ms. Clemens, Abdullah, and Sheriff Betts to avoid accountability. They refuse to meet with the Public Defender's Office. The Public Defender's Office comes with very valid suggestions. They refuse to meet with them. When members of the Board of Oversight show up to look at the jail, they're locked up and charged. 2 weeks ago, I filed a lawsuit against a police officer for beating somebody with Professor Roediger here. We filed a lawsuit of an officer beating somebody in the CJC. And their response is, if I have documents that I want to pass about an employee of the city beating somebody, I need to give it to the city so that they can review it before it goes to my client? That's insane. We're also here because the jail specifically went out of their way to punish Professor McGraw for having the nerve to take a picture of a disabled detainee who is not guilty of anything, lying on the ground in his own feces after complaining about it. When she got the proof, the response wasn't, oh my God, you're right. It's, how dare you? You know, I've got some friends who are very involved in watching the Young Thug trial on TV. This is just like the judge who got caught doing something bad and turned it into, let's not talk about what I did bad, let's talk about how you found out. This is also gaslighting at its extreme. Accusing public defenders of dipping their pieces of paper in PCP to bring it into the jail is quite simply insane. And the reason I call this gaslighting is because we actually do have evidence of drugs being taken into the jail by corrections officers. We have evidence of abuse in the jail by corrections officers. I don't know of a single public defender who's beaten up a detainee in jail. I don't know of a single public defender who's beaten up a jailer. I don't know of a single public defender who's taken drugs in. I don't know of a single public defender who's engaged in a gladiator war where they put detainees to fight each other. Every one of those things has happened in our jail and in the workhouse before that. When I was in law school, I was allowed as a student to do, and I might be jumping the gun here, and this is for Alderman Aldridge's bill, and I can save this for when we talk about that. But I can tell you that when I was a law student at Washington University, I was given a full tour of every inch of the workhouse. Now, as a civil rights attorney defending people in there, I can't see it. That doesn't make any sense. Maybe I should just ask one of my interns to do it for me. It's wild that I have less access now than I had in law school. I also represent victims of crimes. I represent a family in Alderwoman Velasquez's ward, who the father was murdered in broad daylight by a person who may have serious mental health issues. That case floundered for months because the state of Missouri could not get a mental health professional down to evaluate him. Judge Mason quite simply lost patience and ordered this to happen. This has gone months past the statutory requirement. And when the employee of the Missouri Department of Health finally showed up and went in to interview this person to determine if this person was competent to stand trial, a trial or outcome that this family has been waiting for, the mental health professional was denied access because she had an iPad and because a non-mental health professional determined she didn't need it. That delayed the case by months. That kept this family in fear that he would be released for months. That made the taxpayers pay for him being in jail for months. That angered a judge for months. This is because we don't have rules there that are at all consistent with what else is happening throughout the state. In my immigration law context, I have detainees held in jails everywhere. Lincoln County, Troy, Potosi, even used to have them in downstate Illinois before Illinois stopped ICE detention. I would just show up, interview my people, walk in with a laptop, show my bar card. They know that if I do something wrong, I will lose my license. None of us are willing to do that on a single case when we have hundreds of cases. The last thing I'm here to tell you is how this will play out. If the jail doesn't change, and if this body does not make the jail change, this will play out in one way, and that is with organizations like mine suing the jail and getting paid hundreds of thousands of dollars, not millions of dollars a day. I've got 2 kids who've got to go to college. I'm totally fine with that. Works out well for me. Don't think it's the best idea for the taxpayers. You have any other questions for me?
Does anyone on the committee have any questions for Mr. Caselli?
I have a lot of questions, and I'm just, even though this is clearly not our first time hearing these testimonies and hearing these awful accounts of what's going on in CJC, and everybody knows I have a unique perspective being incarcerated before. So it's a lot. I just want to keep listening. But, I just really appreciate you all because this, again, even though we have heard a lot, I haven't in this committee heard you all's testimonies, and it hits even different from some other ones that I've heard. So I just thank you all for being here today. And if anything comes up, I don't have no problem with raising my hand and asking my question. But
I will point out one major change that I'm jaded when it comes to this stuff.
Yeah.
One thing that utterly shocked me was when Judge Hogan issued an order, and within a week, the jail said, we're just not going to do it. I don't even know how to process that.
Thank you, Mr. Javad, for being here today, and all the work that you do on behalf of so many victims who may not have access to get representation. I know you do a lot of pro bono and just trying to represent people. Not so much of a question, I guess, just more of a comment that I think is important for people that is listening, and wherever this is going out. You know, I know you have a law firm. I know we have our public defenders here. I think it is important, like you said, if we don't do something now, you know, what the outcome will be for the city and attorneys saying they will sue us. And I don't think we're in the best place right now for any more lawsuits after the loss of the earnings tax. So I think that for whoever's listening who have the powers to be is important that, you know, we try to get this right, because even from my conversations with some of the attorneys, you know, I don't think, I can't speak for you guys, but, and just also know some of you all that the intention isn't bad of like, we just want to raid the jail. You know, you're trying to do something to make sure that your people that you're representing is getting the proper information, the proper documentations for court, making sure they're not being harassed, making sure they get their medications, and making sure that they're not sitting in feces, which we have seen is something that is happening. So I think there's been a lot of powerful things that have been said, and I know there's more to come, but I think it's critical that the ones that are listening, that the last thing we need is another lawsuit to potentially, you know, hurt the city of St. Louis. Who knows, maybe win or loss, but if that is a win on the opposite end, we need every penny and dollar right now as the earnings tax is in limbo. So that's all I want to say.
Thank you, Alderman. Looks like Alderwoman Velasquez has her hand.
I have more of a comment than a question. I just wanted to, thank Alderwoman Senier for bringing this bill forward, and wanted to thank all the folks who are here testifying, including Mr. Cazelli, a constituent as well. And I think, you know, making sure that why it's heartbreaking and upsetting to hear this information, making sure that your experiences of what's really happening, having that be on the record for the public to hear is incredibly important. So thank you for taking your time out to do this and be here with us today.
Thank you for that, Alderwoman. Just to add to that, I think it's really telling based on your testimony here today. Oftentimes when we hear about the Justice Center, when we hear about the workhouse, when we hear about any detention facility at all, we hear about the men and women who are being held in that detention facility, which, you know, always then you're talking about the defendant side of the equation. I think it's really telling that you're bringing up very compelling points to me regarding both the prosecution side and the victims, ultimately the victims of crimes. You know, if something's being done that's preventing or delaying a meaningful hearing on something for months at a time, I know that anyone who has been the victim of a crime or who cares about someone who's been the victim of a crime, the time that people are waiting for what justice is and what justice looks like in that particular case is mentally very tough. And so to then hear, oh, it's going to be delayed 3 months or 4 months again, is got to be beyond frustrating. So I just wanted to also kind of point a light at that and said that's a really important piece of this puzzle as well. Not that the rights and constitutional rights and general well-being of the people being held there aren't important, but this is bigger than that even. This is literally the entirety of the criminal justice system. and it's causing, a stick in the spokes of the whole thing.
Absolutely.
And that is something that we certainly need to address.
And in line with that, as I said, I think this is a great bill. I don't know if it's appropriate for me to make suggestions. I would make 2 changes to the bill.
Sure.
One of them would be to expand this to include access for mental health professionals and people that are needed, medical people. They should be, professionals who are helping with the defense, mental health professionals, doctors, they need to have unfettered access. And then the other thing is, bills only matter if they're enforceable. $100 to $500 fine, I can absolutely see, based on the lack of transparency that the 2 leaders of the jail have been proud of, that they would just pay those fines. It's not coming out of their pockets and all that. I would amend those fine provisions to include an attorney's fees. Because if you're going to make somebody bring this case forward, then you need to make sure that attorneys are willing to take it. So I would add an attorney's fees and costs for provision.
Understood. And I was actually going to ask the sponsor, but I'll have any thoughts on this. I was wondering, just kind of inside my own head, if it would make more sense from a just kind of speeding things along and keeping costs down perspective to allow the municipal court to deal with this.
I would actually be against that. The municipal court here, the judges are appointed by the mayor. The attorneys are from the city councilor's office, which is appointed by the mayor. It's not an independent organization. And to be honest, the judges want these cases in the circuit court. They want to see change in the jail. So I would not do it in the Muni court at all, because it's not an independent structure. When the city councilor who's advising both of these people to not let the commission in because of a made-up training, and that's the person who's in charge of the prosecutors in the municipal court, come on.
Sure.
But I do think putting an attorney's fees provision behind this puts enough teeth into this that the threat of the lawsuit would absolutely make the city fix this beforehand. All you need to do is get hit with 2 or 3 attorney's fees. My federal court attorney's fee rate right now is $540 an hour. If they want to,
And how many hours do you think it would take you to pursue a case like this?
40? So 20 grand?
Okay, yeah.
Yeah. I think you just need one of those and people will change the way that they're doing things. And in the end, let's just be clear. We're only asking them to do what everybody else is doing, what the county is doing. We're not asking for something insane here. It's what everybody does.
Sure. No, I appreciate that. Does anyone have any further questions? Or do you have any further statements?
Just that Alderman Aldridge said something rude to me, and it made me sad.
Alderwoman Saunier?
Okay, I just wanted to make sure that there's no, once they completed, did you want to do this before public comment, that there was no one else who was trying to give public comment?
Yeah, does anyone have any questions for either the sponsor or any of the individuals that made the presentation before we move to public comment? Okay, not seeing any hands pop up. So if you want to say anything before public comment, feel free, or else we'll move along to public comment.
Yeah, honestly, I think the attorney said everything there was to say. I don't really have much to add to that. I'll come back and close before you all, but I would just echo that I think we have to center people, whether it's the folks who are in charge of defending the clients, whether it's the folks who are prosecuting the clients, whether it is the detainees themselves. Like, we have to, center them. And I would just hope, by the time we get to taking a vote on this, we're not having a discussion about whether or not something is wrong, because I think clearly there's something wrong with this. And I think that it's our job as legislators, as political leaders of the city, but specifically as the Public Safety Committee, to do what we can to I don't want to say to make the system do what it's supposed to do, because in some ways I think the system is doing what it's supposed to do, but it's our jobs to do what we can to mitigate that harm at least.
Thank you. And with that, we'll move to, no, please come forward, yeah.
One more thing.
Sure
Because
thing.
I thought that was important, what Alderwoman just said. I didn't want to relitigate the past, so I'm not going to stand up here and do that. But I want to emphasize to you that the judiciary, as you know, has tried to assist with this in the ways that they can. Our office has definitely done that. Professor McGlaw's clinic and the institutions of St. Louis have tried to do that. The private bar has tried to do that. Failure to act by this committee on this important bill, I guarantee you, will lead us exactly back here in however long it takes to bring these issues back up, because there has been no history to suggest that something other than this kind of bill is going to get us what we need. So what I don't want to have happen, the reason I stood up one more time, is because I don't want the suggestion to be that, okay, more conversation can happen and things will get better, because that is what has been attempted ad nauseum. So I think the Alderwoman's bill is, at this point, beyond necessary. It is the only thing I think we have left to make this happen. Thank you.
Thank you. So with that, we will move to public comment. Madam Clerk?
We have Janice Messiah. Janice Messiah. In support.
All right, could you please state your name for the record?
Janice Mensa.
And do you swear or affirm that the testimony that you're about to give is true to the best of your ability?
Yes.
You have 3 minutes. Please proceed.
Okay, thank you. So I'm Janice Mensa. I live just a few blocks away. I was the first chair of the jail oversight board set up by the Board of Alders and the mayor, and then I was later vice chair. I'm deeply committed to my neighbors, the members of the public waiting for their day in court while at the jail. I now find myself in court and on trial for that commitment. In the last 2 years, I have become intimately familiar with the lengths that the city will go to in their commitment to shrouding the jail in secrecy. So far, the city's version of access has been invite only, and as the lawyers have said, the invite list keeps getting shorter and shorter. Jail access to the stakeholder groups highlighted in this bill is essential to any semblance of justice in our criminal legal system. Personally, I'm not convinced that there has been or even can be any justice in our criminal legal system, but I recognize that those are high hopes for the city of St. Louis. This bill is not asking for all that much. Alders Saunier and Aldridge are merely asking for openness and honesty around the injustices we know are occurring today. I'm in support of the spirit of this bill, and to that end, I want to point out a few concerns I have around the language. Bill 12, page 2, section C talks about not being allowed to ask detained people or staff about matters related to pending litigation, which I believe can be used as a loophole to prevent access, as it was used with the Detention Facilities Oversight Board. Bill 12, page 2, section D talks about allowing clergy inside, and I think that the stipulation that it must be in compliance with jail policies is another possible loophole. Bill 12, page 3, section E talks about requiring public notice when access is denied. I think this is good in theory, but in practice, the city has no real incentive to follow through. I'd recommend essentially accessible public posting where violations of the ordinance and access denials are reported by these authorized individuals themselves. And another suggestion I heard about fines, however those fines are decided, I think would be something positive as well. I'm not familiar with the practical use of the severability clause, but I thought that also looked good in theory. I like the emergency clause. I think it's good to see a sense of urgency, at the very least in writing. And then just finally, overall, I think this bill is good in theory, but in practice, there needs to be an airtight method of preventing the mayor, the public safety director, the warden, and the city councilor's office from just ignoring the ordinance, using loopholes, and generally slow working justice. And I think part of that prevention will be in writing, as it is here, but it also takes systemic changes and individual effort and courageous personal responsibility on the part of the authorized individual and concerned members of the public. And just the last thing I will say is that one cost that I don't think has been mentioned is the numerous jail deaths at the CJC. As I've stated many times before, the CJC is one of the deadliest jails in America, looking at deaths per inmate population. And we come back to this exact room time and time again to discuss this. And I just want to remind us that, as you said, we want to think about the victims here. And obviously the victims are the victims of the crimes that charges are being brought up against. But I think our city also makes victims out of people awaiting trial by having them in the CJC. Thank you.
Thank you. Madam Clerk,
That will be all.
is there any written testimony?
I did not see any written testimonies in the drive.
Okay, thank you. Alderwoman, please proceed.
Okay, thank you, Chair Narayan, members of the committee. I really want to thank all of you all of the attorneys who came out today. When I realized that we have public safety on Thursday afternoon, I was really nervous because I know a lot of you all have courts and have been in courts all day, and you came here for courts, and obviously you have a very important job to do. So I just really thank you all for coming out, because you all's voice and testimony is really important to get on record, to have a part of the public discussion. And I think to that end, to my colleagues, what I would say is that there are several people who are uncomfortable with coming forward or uncomfortable with talking because they're fearful of other consequences that they may get. And there's also folks who are not here and who are here that have instances that are so grotesque and are so unethical that they didn't even want to say them on record, that they didn't even want to, they didn't even want to say that and have that a part of the conversation. So what I just want to leave us with is just a strong urgency of now. I want to make sure that it's on record that I have reached out to Commissioner Abdullah. I've sent her the legislation. We've had a conversation over the phone. I haven't received a response yet. I do have a meeting coming up with the administration, and so perhaps I'll get her feedback in that manner. I love conversation. I love dialogue, and I think that's a key part of our job, but I'm not going to stay in this box of just waiting on conversation and waiting on dialogue. The great thing about this bill is like these practices and standards are all happening all over the place in neighboring municipalities, but even across the country. So I look forward to hearing, specific feedback on the bill, but there's really not much to attest in terms of should attorneys be allowed to have their phones and their laptops and their computers or tablets or whatever they need. The system comes with a level of accountability for attorneys. It's called their law license. It's what they need to practice. So, I think it's really important. I don't know how you could argue against that. I don't really know, the practice that we're hearing about not being able to pass papers. That is an obstruction of justice. That is stopping people's ability. If I need to show you your ticket, a fine, a citation, if I need to show you a record, I might have something medical that's relevant to your case. I need to show you to that, and expecting lawyers to either not pass papers at all or leave them at the front desk of a facility is a violation on their end, and also a disservice to our residents and our detainees who are within the facility. And so I do look forward to conversation. I look forward to feedback. But again, these are common sense practices that are in this bill. This bill was filed months ago, and I waited because I was hoping that we might see some traction or see some action of something else that might indicate that it wasn't necessary. But if it is necessary, I think the next step is that all of us have to do whatever is within our power, because it's not extravagant to say on top of taxpayer dollars, on top of the obstruction of justice, that it is a matter of life and death, that the people in our communities, they deserve justice, they deserve results for their cases. As the attorney said today, they can't get that if attorneys can't do their job. And the detainees who are within the facility, they deserve to know what's going to happen and not to be held within a facility for so long. So I would just leave us for that, and I just want to make sure if you all have any further questions about anything in the bill, if you want any clarity, I received all the notes today. I'm sure I'll have, an update, either an amendment form or committee substitute from, to make this stronger, but please reach out to me. Please communicate to me. I would suspect that we have at least another week or two before I'll be back in front of you, but the next time I come back in front of you, I will be asking for a vote.
Thank you, Alderwoman.
Thank you.
All right, with that, we're going to move over to Board Bill 12. Alderman Aldridge, you are recognized.
Thank you, Mr. It's pretty loud. Thank you, Mr. Chair and members of the committee. Madam Clerk, could you read the summary of Board Bill 12?
Board Bill number 12, introduced by Alderman Rasheen Aldridge, co-sponsors Alderwoman Alicia Sanye, An ordinance that authorizes certain persons to access and enter city correctional and detention facilities for the purposes of oversight, transparency, and accountability. The ability to access city facilities that are maintained by the Division of Corrections is intended to be codified under Chapter 16.12 of the Revised Code of the City of St. Louis.
Thank you, Madam Chair. So this bill is I would say a kind of hand in hand that goes with Board Bill number 11. Before I walk through the bill, I will talk about, I think, why this is necessary. I will say, I think this committee, in my time of being on public safety, we have took it very serious from the work from Alderwoman Clark Hubbard has done on DFOB and making sure we expand on that. We've had people in from the jail to talk about what we can do better as a committee. So I know when it comes to oversight and I know when it comes to transparency, I know each member on this committee does take that very seriously. And I know this isn't a game, as we say in Ferguson, this ain't no game, this ain't no joke. So I do want to also thank you all for y'all leadership for taking these situations serious. So Board Bill 12, like I say, is an add-on to Board Bill 11. I wouldn't say an add-on, I would say they go hand in hand. It is also making sure that we have access in our city jails. It goes without saying, for the last year and a half, we continue to hear about necessary things that are going on in the jail that doesn't put the city jail, let alone the city, in a good limelight. If it's been stories or if it's been complaints from DFOB members or just from attorneys themselves of just the lack of access to our jail. So Section 2 is the definitions that define what we mean by access, which is the access to detention facilities. We didn't just say the CJC across the street. Who knows if the workhouse ever becomes back open or if we get another detention facility in the city of St. Louis. So any detention facilities in the city of St. Louis. We define who has authorized access. So that would be the division of the Department of Public Safety, the mayor, the president, and members of the boards, municipal and circuit court judges, city councilor, prosecutors, and defense attorneys, so that they could be able to see their clients as well as detention facility oversight members. As you continue through the bill on page 2 of section D, we also allow clergy members to have access to the jail. It's pretty straightforward. It is any time without any warning that members will be going in. Section E, I know this is something that Janice brought up. If you know how to change that, there is a written process if access is not granted, which that should be an open public record and subject to sunshine. Section 5 lays out the severability clause, and Section 6 lays out an emergency clause. A lot of this language that we use in this legislation came exactly from our state statute. So this is something that is done on the state level. As being a former state representative, when I was over the minority member on the Corrections Oversight Board, any state rep at any time, and I know myself and State Representative Kim Collins did it very often, where we would go to any prison from Bonne Terre to Pelosi to the prison in Jefferson City. And as elected officials, we had access to go in at any time to be able to walk the jails and make sure that things are just happening in a proper manner. I got a lot of letters from people that was inmates that didn't have an outlet outside of their attorneys to be able to reach out to elected officials to say, hey, this is what's really going on, and we need to make sure that their eyes and ears, that make sure these detainees are being handled properly. I think it was mentioned earlier, what's even more crazy about the CJC is these are individuals that have not been charged at all. They have not been found guilty. These are individuals that still have due process. But over and over and over again, it's crazy how the CJC continues to kind of be called one of the worst institutions when it comes to detention facility locations to our counterparts in St. Louis County. And I mean all the way out to St. Charles, which I would be nervous being held in St. Charles, but it sounds like attorneys even have better access getting to their individual clients compared to CJC. So we already currently in the city of St. Louis kind of have this policy that's not an ordinance where older people can go in the jail. But it's been times where I try to go in and I've been denied. I know under previous alders have said they've been able to go in the jail and have access. It's really a gray area. So I think it's always important to codify things in law to ensure that we do have true oversight and transparency and accountability in the jail. Like Alderwoman Sonye said, you know, I've sent this legislation to the commissioner because at the end of the day, we're trying to work to ensure that the jail is safe. We're not trying to attack the commissioner. We're not trying to attack any administration. But what we're trying to do is make sure that there is oversight and transparency so that we as a Board of Aldermen, and especially on the Public Safety Committee, can be a help because people reach out to us as well when things go on in the jail. So this isn't a target at them, but more importantly, trying to work with our departments so that we can be a help from elected official standpoints. And with that, I will close. I think Alderwoman Sonye covered extensively, very well, and very similar legislation. I think it just goes a little farther in who has that access. I know hers focus on attorneys. Mine's have attorneys in there as well as other individuals, but same concept of ensuring people have due access to a facility so that we can make sure it's being ran properly.
Thank you, Alderman. I have a few questions because I'm just a little bit confused here. So when you're talking about access here, do you mean that any of these authorized individuals would be able to go to a detention facility and like just kind of poke around, or do you mean that they would have access to an individual being detained?
So they would have access to the facility, just like when we went on our tour. I wouldn't say poke around, but I think if, like these lawyers have said, they're not going into the jail just because of the fun of it. I think if they go in or an elected official go in, it's because we receive complaints of something that's going on. So outside of, you know, talking to individuals who are their clients, as elected officials, as we went in, you know, we went on a tour where we was only allowed within a time frame access to only certain locations. So this would allow access to all the cells, of course, when they are in their cell, as well as potentially the kitchen or any other medical holding staff, holding rooms, the sheriff's side, but access to the facility completely.
Okay, so it'd be the complete facility and anyone who was an attorney, essentially anyone who was an attorney or any clergy member. I'm not sure what a recognized denomination is, but anyone who, I would imagine anyone who themselves out to be a clergy member could then enter the facility at any time with no prior notice.
Correct. And there is a process. If they are denied, they have to, if they cannot get access, that there has to be a written process of why they were not granted access. I know this may sound, again, maybe new, because just the way that you're asking, you seem a little off. But again, this is something that we do literally on the state level, where people go into facilities anytime. Prison, that is supposed to be a much more harmful and scarier place, because these are people that have been convicted for serious crimes. And I mean, go into like the hard cells where the most, I wouldn't say troubled, but ones that have more trouble, again, still have access to be able to go into those.
So I'm an attorney. Is what you're telling me that I could show up to Potosi right now?
No,
I'd
on
like
the
to
state
around-
on the state level, they have it lined out where yes, attorneys and state representatives can go in anytime. So yes, they do have that ability to be able to go in. Yes.
And then say I wasn't an attorney, but
You wouldn't have access.
I was a clergy member. I got ordained wherever.
Clergy goes in all the time with the NAACP when they do pop-ups to also pray for people. Yes. They have access.
So that's what's happening under the state level right now, is what you're saying?
Correct.
Okay, and then just, I guess, one other thing that I see a potential conflict here in between 11 and 12. So
Page 1.
page 2, sections B and C, I see a conflict with page 3, line 3 on down of Board Bill number 11, because it looks like, so an authorized individual can access a detention facility at any time without an appointment or prior notice. In order for an attorney visit, though, then you have to have a 1 hour's notice at time. And then, so I'd just be interested in how that would potentially work. And then also on Board Bill 12, page 2, line 12, that an authorized individual shall be prohibited from asking detainees and correctional staff about any pending or ongoing litigation. So does that mean
That would have to carve out outside of defense attorneys and prosecutor people that is something that I know we need to clean up. But
Okay.
attorneys would be able to. But for as like alders and clergy and the president and the mayor, we shouldn't be asking about pending litigation stuff. But that needs to be cleaned up to make sure that the attorneys have the ability to still talk to their clients. So that's a cleanup there.
Okay, I was just wondering if it was like, oh, when I go into the facility, I have to decide if I'm there in the facility or if I'm there to represent my client right now, like, and which would, if I am there under 12, then I'm not allowed to talk to my client. I have to, leave and come back and set the appointment and,
Yeah. So I think once we take out that C on page 2, that would still allow attorneys to go in to talk to their client or to do a jail visit in general.
Sure. Sounds like Alderwoman Saunier may want to weigh in here on my question.
So I think the difference is that when we talk about attorneys, we're talking about their visits with clients. So that's why that 1 hour notice is there, because you need to be able to get a detainee ready account for that. And so when attorneys go, they're usually specifically going to have contact with the client. When the parties that are within Board Bill 12, that's Alderman Aldridge, an elected official, a member of clergy, they're not having a visit with the client, they're having a visit at the facility. So that's why those two things are different. They're not in conflict, they're to account for those differences there, that, if you just need to go in and get a tour, there should be someone there available to give you a tour. But if you need to have contact with the detainee, and again, that notice is required it's not required for non-contact visits, but if you're trying to have a contact visit with the client, we do want to be fair to the facility and allow that time.
Yeah. And I think Alderwoman Saunier hits it. Hers is talking more about attorneys having access to the client. This is saying access to the detention facility.
Right.
Sure. Yeah, I guess my only real concern here, because I get it, they're two different things. My only real concern here would be like the actual like nuts and bolts functioning of this, because I imagine that if an attorney shows up or a member of the clergy shows up or an alderman shows up, that it's going to take a member of staff away from whatever it is they're normally doing to kind of escort the guest, I'll say, around. I doubt they're going to just be like, here's the keys.
No, of course it would be like when we took our tour, we were escorted by the commissioner, the deputy commissioner, and one of the staff members.
And
Just
so,
on the same as the state level, when you go into a prison, you're escorted by a guard that would be able to get you access into pods. You're just not going to hop on the elevator and just be able to walk into a pod.
Sure. No, but then hearing, what the public defender office was saying earlier, that sometimes they're calling these floors and no one's answering for periods of time. I'm just kind of thinking out loud about the actual like way that this would function, because if and I wish that I wish Ms. Clemens Abdullah was here to weigh in on this, and hopefully she
I think
would.
we do too, and we both sent an email.
Yeah, hopefully she will be in the future, because I would just be curious, not the spirit of this at all, but just the actual effect of the manpower that it would take to get this done potentially, and what that looks like if we have it. If we don't, what can we tinker with here to make it so that the people who do need access to the facility can get it in a timely fashion, without kind of a staged tour, while at the same time not putting detainees at any risk because of the guards being pulled away from their actual like obligations in order to walk around with me or whatever. But yeah, hopefully, I know that you're not looking for a vote here today from our previous discussions. So hopefully, Ms. Clemens Abdullah can talk to us on this and weigh in on it.
And I would just add to that, I don't think the question is what's the way. I think is the city gonna have the will to be able to do something where why is a guard not answering for those many hours and they're actually in that location? We have, I'm sure during those hours while we may be down correctional officers, we have enough staff that Ms. Clemens said during those hours when people are working, they have enough guards. So I think one of our biggest issue, and it's good to make sure that all these nuts and bolts are checked, but I think a lot of times it's in St. Louis be slow to the change because it's not the way we do it. It's the question: do we really have the will to want to do something?
No, I understand that, and I certainly agree with the spirit of this bill. I'm just wondering if we maybe need to take a look at the amount of tours that would be going on simultaneously or something like that, to make sure you didn't get 3 people in who split off into 3 different locations and all of a sudden you pulled 3 guards away.
Well, I'm sure if it was 3 people, the guard, like when we went, the guard, it was 4 or 5 of us, and there was 1 guard. I think.
Yeah. No, and I agree with you. I on that front, I just if they can access the facility and it's the whole facility and no part in or around the facility shall be off limits, we just need to make sure that we can account for that. And I think there's probably a way to do so. I just want to, like I said, I wish Jennifer Clemens was here just to weigh in on that and give us a estimate of what that may look like from.
I definitely think I talked with the commissioner because like I said, as I talked with you offline, Chairman Ryan, since this is public, definitely wanted her to be here, talked to her weeks ago. Again, not trying to make her job difficult, but how do we make sure, like you say, the nuts and bolts are correct? But at the same time, I can expect that if not her, the administration, and thank God they are meeting with us, Alderwoman Sonia, to figure out how do we make this work. As you know, in legislation, there's something the administration want, and it's sometimes we have to say if it is reasonable that we can do it, that doesn't be the harm to the good of the legislation.
Absolutely. No, sometimes you got to file a bill to get the conversation moving. I certainly understand that. With that, I'll move on down the line here. Alderwoman Clark Hubbard, any questions? Alderwoman Keys.
Thank you, Mr. Chair. No questions at this time. I would like to be added as a co-sponsor on this and 11, please.
Noted.
All right, Alderwoman Velasquez.
No questions at this time. Thank you, Alderman Aldrich, for bringing this, and I do look forward to the next conversation when I hope the jail commissioner is here as well.
Thank you, Alderwoman.
Alderwoman Saunier.
I don't have any questions. We worked together on both of the bills, so I'm just grateful for your leadership, and I'm glad that we were able to, collaborate on the issue. And I really appreciated the insight that you had as someone who's been on the state level and seen how this worked at prisons. I think that was very helpful as we put both of these bills together, and I look forward to us continuing the work.
Thank you, Alderwoman.
And I see Alderwoman Key's hand is up. Did you have something to add, Alderwoman?
Just a quick question. I'm hearing, how difficult it is for legal services to be able to come in to the Justice Center. But I am, and I'm sorry, I forgot to turn my camera on.
We got to see that face.
But I am, there you go. And so I'm curious as to how difficult is it for family members to gain access to see loved ones who are incarcerated?
I can't speak that as a family member, but I know from the DFOB side, it has, I'll just say in simple terms, it's also been difficult for families to not even know information about individuals that are in there, but even the ones who have passed away in the jail to be able to get information of how they were passed away in our city jail. That's a good question. I think one of the public defenders.
Yeah, I believe Mr. Mahaffey may be able to weigh in here on this one. Please proceed.
Thank you. I haven't had the experience as a family member, but we obviously have a lot of family members who try to access the jail. My understanding of the procedure. Yep. Too tall.
Yeah, you can also just.
Okay. Yeah. My understanding from both the facility and from family members is that the procedure is that the client at the jail has to request and put on a piece of paper who is allowed to visit them. But in order to do that, they have to meet with, I believe, a case manager in order to effectuate that. Until that procedure is done, there aren't visits allowed outside of professional visits. And some of the experiences that some of our clients have had is that getting that list accomplished in a quick manner is not always the case. We have had family members attempting to visit people, especially when they've been recently incarcerated, and they have been denied access because they haven't been put on the list yet by the individual that's at the facility, but the individual at the facility has told us that they haven't been told about that opportunity yet. I do know there are posted social visit times. I couldn't tell you off the top of my head, Alderwoman, what those are, but that's what I understand the procedure to be. I know there's somebody from the jail to outline that, but that's the feedback we have received, and there has been some challenges for members of a family to go and see someone. And then, quite honestly, if you think about the position of our clients, if you're asked who you want to be able to come see you and you are recently incarcerated, there's a very real stress involved in that situation. You might not be as comprehensive as you would like in that moment through the reality of the circumstance. I have been told it has been difficult to amend that list as well, but again, I don't know the procedure for doing that. So that's the information that I have from the experiences our clients have shared with us.
Thank you for that. Looks like Mr. Caselli may want to add to that as well.
Just really quickly, that is not the procedure in St. Louis County. St. Louis County, anybody shows up, asks to see the person, and then that person can decide if they want to see the person visiting them.
Thank you.
So I think that somebody else pointed out, how many caseworkers do we have? How much time are we wasting on caseworkers running down these lists? How much is that costing taxpayers? Is this just a reason to keep people from getting visits?
Understood. Thank you. Alderwoman Keys, anything
Yes,
further on
thank
that?
you all so much for clarifying, and it's just so heartening to hear that persons who have not been convicted yet of a crime are having to deal with these sorts of things. it's just like watching a petri dish. It's horrible. So hopefully some changes will be forthcoming as a result of Board Bills 11 and 14.
11 and 12, I believe, Alderwoman.
Oops, I am so sorry. 11 and 12. Sorry about that. Got my
Not-
numbers wrong.
I'm not
Just
sure what
thinking of me from the
is, but
14th, that's
hopefully that's a good one too.
Yeah.
All right, Alderman, anything further?
Nope, unless members of the public want to speak, I have none.
All right, Madam Clerk, do we have any public comment on Board Bill 12?
We do not.
Right, does anyone in the room want to speak on Board Bill 12 while you're here? All right, then Alderman, you're recognized to close.
Thank you, Mr. Chair, members of the committee. Like I say, not taking a vote on it today. I do want to thank also Alderwoman Keys for joining on as a co-sponsor, but appreciate you, Chair. You put us in communication with Clemens Abdullah and the mayor's office, as me and Alderwoman Sonye had been trying to also get in contact. So we do have a meeting set up. Again, I think both of us are trying to do the right thing. You want to make sure we're not overstepping, but also understand that this is the time now to do it. So won't take a vote today. I think both of these are truly important bills. I know the Alderwoman said next time we meet, if it's next week or the following week, that she'll be taking a vote. I want to make it very clear that hopefully next week, next Thursday, we'll be taking a vote, because I think some of these things are just common sense and others that can just be nuts and bolts fixed out. So look forward to bringing this back up next week and taking it up.
Thank you, Alderman.
Thank you.
With that is all of the board bills that we had for review today. Was there any written testimony regarding Board Bill 12, Madam Clerk?
No.
Okay. Do any of my colleagues have any announcements? All right. With that, I will entertain a motion to excuse Alderman Oldenburg for necessary absence.
So moved. Second.
It's been moved and seconded. All in favor signify by saying aye.
Aye.
Opposed?
Aye.
All right. So with that, we have excused Alderman Oldenburg. We have nothing further. I will entertain a motion to adjourn.
So moved.
All in favor signify by saying aye.
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 We stand adjourned.